almost forgot to put on my headphones. Yes, I have paint on me. Yes, I have paint on me. And of course that came up in the video because that's just the awkward person that I am. So how are you, everyone? This is Monica here with the Best Interest of the Parent. So glad you're here. So from now on, we're going to be doing our weekly live streams on Tuesdays instead of Mondays. So Tuesday, 8:30 p.m. So do mark your calendar. Hope you show up every week with questions or just your attention, and your presence would be wonderful. So just want to make a really quick announcement. So I've been running this promotion where if you leave a review on my podcast channel, after, of course, listening to one or two episodes on the podcast, and leave a review on the podcast, I'll enter you to win a free 75-minute coaching session with me. In exchange for your review, you would be entered into a contest. And the drawing would be a week from today, June 1st, which is my birthday and also the birthday of my course, The Best Interest of the Parent. We share the same birthdays. And I have gotten a lot of parents reaching out to me indicating that they can't leave a review for whatever reason. Either their tablet isn't compatible, they have an Android instead of an iPhone, or they have a desktop instead of a tablet. And I personally have tried to leave a review on other people's podcasts because I was testing it out and I ran into similar issues. So if I can't even leave a review on other people's podcasts, I don't expect you to be able to leave one on my podcast. So if you're having issues, then do send me a private message on Facebook or an email and leave your review through that channel, providing that you actually listen to a couple of episodes. And I will then use that as your entry. Okay, I hope that makes sense. I'm really sorry for the inconvenience on that. I didn't know that it would be not user friendly, and other people have had issues, and other people who own podcasts have said that they have a hard time getting people to leave reviews for that reason. So, okay, so today we're going to be doing a Q&A session, and I want you to put in a disclosure here that I'm not an attorney, so nothing I say is legal advice. The information that I give is based on my personal experience in the family court, what I've observed other parents doing in the family court that I have found to be successful, and also the advice that I give that's anything legal related is not legal advice. It's just what I would personally do. That said, I believe we should all be educated on our rights, and education on your parental rights is available everywhere. Education on your rights as a private citizen in this country, United States, is available everywhere. You could open up an 8th grade civics book and learn a lot about your rights that way. So the stuff that I share with you, even though I'm not an attorney, it's not that difficult to learn about your rights. That's not coveted information by the bar industry. The bar industry is not as exclusive as you would think. Of course, they're great with helping you apply strategy and how to do it and stuff. But I think that the bar industry has had to be a presence in a lot of divorces because the system is so corrupt. If the system was functioning as needed, we wouldn't need to depend on attorneys as much as we do. So someone just asked a question. I will get to other questions at the end of this Q&A session if we have time. I have 11 questions that came in. I'll try to get to all of them. In the very least, I get to most of them. So I'm not an attorney, so that's my first disclaimer. Nothing I say here is legal advice. It's just what I would personally do based on my knowledge of the law. And I believe we need to start taking more control of our personal family court cases and not depend so much on the system to manage our divorces for us and our custody cases for us. A lot of times parents will just simply rely on like an evaluator to do a lot of the work, or a guardian ad litem, or just let's see what the judge wants. Like they just kind of surrender to the judge, surrender to the system. And I think parents need to take a stronger role in their matters, because we're not getting any positive results in the family court system. I mean, just look around you. You're going to see fatherless and motherless kids everywhere. And kids are not having good outcomes. We have a very sick population of kids, 10 to 18, very, very sick. A lot of them have mental illness. Over half of them are on some sort of medication. A lot of that is attributed to mental health challenges. So that's my first disclaimer. My second disclaimer is that I'm not trauma informed. So if I talk about like narcissism and abuse, that's not my area of expertise. I've never taken abuse training. I'm not trauma informed. I don't get into clinical issues that are related to challenges with the narcissist. So what do? I teach courses and workshops for parents to help them build empowerment strategies and healing strategies for themselves, because I am a certified health coach, and I help parents get through the family court system, putting their own value system front and center, their own backbone, and taking charge of their own case, and how to set proper boundaries with the narcissistic system, an evaluator, a GAL who's trying to mow you down as a parent, a judge that's trying to mow you down and bully you, how to stand up to these people, a strategy to stand up to these people. That's what I help parents with. And I think using your rights is a huge strategy. Using your rights, setting boundaries, taking care of your health, and then having the right kind of mindset. So my course that I teach, The Best Interest of the Parent, encompasses 4 quadrants. And those 4 quadrants are boundaries, education, knowing your rights, and setting boundaries, obviously, and then having the right attitude and performing regular healing rituals on yourselves to heal from the trauma that you've already endured, either from the narcissistic parent or from the system itself, and having your children taken from you. I'm so glad you're joining us, Vanessa. It's really nice to have you. And I love that name. I'm reading a book right now, and the main character's name is Vanessa. And my older daughter's middle name was going to be Vanessa for like the longest time. So I just absolutely love that name. And there's the origin of your name is very interesting. I'll send it to you. I just learned the origin of the name Vanessa, and it's fascinating. So anyway, okay, so we're going to get to the very first question. This is actually kind of funny. So the first question that came in was, why did you lose custody of your child, and why was he not returned to you? So 5 years ago, I would have told you I lost custody of my son because I didn't have a high enough GPA in college, and the judge didn't think I had good job prospects. I lost custody of my son because the judge decided that I had too many boyfriends in my 20s, and I was likely to have a lot of boyfriends in my 30s because of it. I was 31 when my son was taken. So the judge looked at my 20s and said, oh my gosh, Monica had like 8 boyfriends in her 20s. And because she had 8 boyfriends in her 20s, she's going to have 12 boyfriends in her 30s, and that's not good for her son. And I would have told you also, what else did the judge say about me? The judge also said I was volatile and quick to rage. And I would have said I lost custody because the judge thought I was volatile and quick to rage. So those are like the excuses that were given when I got my orders, my court orders. So 5 years ago, I would have told you it was those 3 things. And so, but now it's been 11 years. I'm going to tell you my son was taken from me because that is the only way to create transactions in the court system. Because when a child is taken from the protective parent, that protective parent has to continue to go back to court to try to bring themselves back to equal status. Bring themselves back to their child's life, basically. So if you could take something away from somebody and then charge them a lot of money so that they can incrementally work their way into the system or through the system to become whole again, that's a brilliant business model. That's a great business model. If you could throw a brick through a bunch of windows, if you own a window company and you have someone throw bricks through windows all the time, you're going to make $1 million replacing people's windows all the time. So if you could destroy something and then charge money to make that thing whole again, that's a tremendous business model. So the family court business model is brilliant. You take something away from somebody so that they have to fight and grovel and spend money to get that thing back. So that's why my son was taken, because the court probably knew that I was the kind of parent that would continue to fight and get my equal rights back. And the court was correct. The court predicted that I would spend a lot of money, and I did. I ended up spending maybe another $20,000 getting my son back, and that's not even counting the child support, matching funds or whatever they do for child support. So it's a very lucrative business model to take a child away from a fit parent, knowing that fit parent is going to continue to fight. So what the judge has to do, though, to justify what they're doing is they just have to create some excuses. Oh, yeah, they had an alcoholic parent. Let me just throw that in the order. Oh, they testified, they cleared their throat too many times. The parent is too nervous to raise kids. Let's just throw that in there. The parent showed up late to court. That means the parent's going to show up late to bring the kid to school. So the judge is just going to make up stuff to throw into the orders. It's just copy and paste. I mean, I had one judge actually put stuff in the court order that never even happened in the court case. I've seen judges put stuff in court orders that were never even talked about in the actual hearings. Like the judge will say, like, oh, the parent has a vicious dog, and the parent's not even a dog owner. So sometimes the judges, or they just get so sloppy and lazy with their orders that they just throw crap in there. And so what parents need to do is you need to stop freaking listening to those reasons in your court orders. Because if you are truly unfit and bad, you know, and like you had issues, there's state programs that you could take to rehabilitate yourself. If the judge took your child away because you were arrested for drunk driving with your kids in the car, you could go and take a state program for $100, graduate from that class, and get your kids back. You know, like, don't we have programs like to help parents rehabilitate their issues? If you lost your child because you were homeless, the state could put you into public housing. The state loves, you know, fixing problems for people because that's how they get a lot of federal money. You know, the state really wants to create that dependency. So if you lost your child for a legitimate reason, you probably have your child back by now. You know, I'm sure there's exceptions to that. But when you lose your child for no reason, what's hard about that is that you can't rehabilitate from anything. How do you rehabilitate the fact that you had a crappy GPA in college when you're in your 30s? Like, how do you fix that? Do you go back to college and get a better GPA? And you know, it's actually kind of funny. When I had my son taken, I had just graduated from massage therapy school like that week. I'm not kidding. I think I graduated like on a Saturday, and then like the following Tuesday I had trial. And so I was literally days from graduating, and I graduated with straight A's out of massage therapy school. So you would think, so if my GPA from college was so bad, why isn't a transcript that's like 4 days old bad, like not admissible? Right. So that's the thing. Like, the judge is just going to make something up. And the other thing that's really, really bad about this kind of thing is that you don't even know what the judge is going to use against you until after the fact, until after your children are taken. Then you read your orders, you go, oh, page 17 on the bottom says that because I got fired from that job, you know, the judge didn't look badly upon that, or I quit this high paying job, the judge didn't like that. You could not have known that you're going to lose your kid 5 years later by quitting a job. And so what the problem with the court system is that we find out what we did wrong after the fact, after we already did it. And we have a lot of case law in Connecticut that says people need to know which laws they're breaking. And your state probably has case law that says that you can't be punished for a law, or for violating a law that you didn't know was a law, because it's not illegal to get fired from a job. It's not illegal to have a lot of boyfriends in your 20s. It's not illegal to not have a good GPA. So you can't know what you did wrong at the time that you're doing that wrong thing. So there's a term called ex post facto punishment. And Ron Palmer with Fixed Family Courts talks about that in a lot of detail, and it's fascinating. So when you could like learn these concepts and you wrap your mind around it, it's going to shift your mindset, and you're going to kind of know how to better respond to bullshit like that when it gets thrown at you. Because when you're in court, you know that your ex is just going to make up some random thing. Oh, got in a fight with the next door neighbor at a barbecue, and they were screaming at each other, and the dog was barking. And like, your ex is just going to make up stories just to try to get the judge to not like you. And so if you can understand this whole concept of ex post facto punishment, then you can better defend yourself. You could think on your feet more because your mindset is in the right place, because you know that you can't be punished for stuff that's not even illegal at the time that you're doing it. So anyway, that was a very long answer. Why wasn't he returned? Well, same thing. You know, he wasn't returned because it's not lucrative for the system to return parents. It's not lucrative for the system to return children to fit parents. If you return a child to the parent, then your money stream from that family runs dry, because now the parents aren't going to be fighting anymore. And the narcissist rarely goes back to court to fight equitable orders. And you don't really see that very often. So let's see here. Okay, I'm so sorry. This particular question came in an email, so I'm going to pull it up because it's right here. And here we go. Okay, here. Okay, how does one bring a motion back to court for 50-50 medical / placement / school, applying either the American with Disabilities Act, or that it's been 2 years and the kid is older, 9 years old, and hates his school at dad's, also hates his stepmom, hates not having more time with mom. So this is a mom writing this question, just for context. Let's see. The ex and his new wife hauled me to court with a new GAL. Okay, so my guess is that in this particular situation, a new GAL showed up and ruined everything. She used to have a more equal schedule with her child. New GAL comes in and just messes everything up. You know, we're all familiar with that, right? And she says, I signed under duress the document to have 0 medical and 36% placement. I'm numb and feeling handcuffed, as maybe others are in the same situation. I would love to hear your stance. So it sounds like from this email, how does one bring a motion back to court for 50-50 medical placement in school? Either applying the ADA. Okay, so definitely apply the ADA if your child is has a functional impairment of any kind. And I talk about this in great detail in my ADA workshop. If you don't have my ADA workshop, I highly suggest that you get it. That will blow open all of this stuff and really help. It just it drills down into that part of your question. So it's very long to explain here in this live stream, but definitely look into the ADA workshop, and I will include the link to that. So, you know, how does one bring a motion back to court for 50-50 medical placement in school, applying either the ADA or that it's been 2 years and the kid is older? So it sounds like you're considering possibly going back to court for a motion for modification because the child is older. Some courts will allow a child aging as a change in circumstances, and some don't. In my particular case, my son simply getting older wasn't considered a change in circumstances. So if a child's like goes from age 6 to age 14, that's considered not a change in circumstances, apparently. I think that the whole notion of change in circumstances is so stupid, because why should we sit around as parents and wait for something to happen so that we can be equal parents? I am not a fan of that. But if you do go back to court for a change in circumstances, I would try I would try as hard as possible to limit the judge's discretion as much as possible. So if you say things like, my son hates his school, hates his stepmom, unless your child's being abused, I would call the police. And if you need a free lesson on how to handle that, let me know, because I do give away one of my lessons in my course on child abuse. So let me know if you need that. Just email me. If your child's not being abused and just simply hates his stepmom. Now, when I say child abuse, look up your state definition of child abuse. There's the state definition of child abuse, and then there's us as parents of what we think child abuse is. So there's a lot of times those are different meanings. And the state can only interfere when there's a state statute being violated with regard to your child's treatment. Unfortunately, we can't always go to the authorities if we just think our kids are being abused. There has to be probable cause that is codified in your state statute for child abuse. I talk about that more in that lesson that I mentioned. So if you go back to court for a change in circumstances, this is not legal advice, I would try to limit the judge's discretion as much as possible. So if you say like, well, he doesn't like his stepmom, he doesn't like his school, that invites a best interest of the child determination. That invites the judge's discretion. You're saying, this is my opinion, judge. What do you think? Do you believe my opinion, or is my opinion enough for you to change the order? Like I said, you're going into the legal system to try to procure an opinion from a judge. And I don't believe opinions belong in the law to the extent that they're in family court. I mean, family court is a court of opinion, and we need to use the laws in family court. And the laws say that you get to be a parent in this country. This is the United States. The state doesn't own our kids. And if you have no medical decision-making for your child, that is a violation of the law. The law says that we get to make decisions on the care, custody, and control of our children. That's in the freaking law. It's in the Constitution. Well, it's not in the Constitution, but it's in case law as codified under the First Amendment. So again, this is not legal advice. Talk to an attorney about this. Just ask your attorney. Aren't parental rights secured under the First Amendment? And the answer is yes, because this is in the freaking case. There's over 100 cases in the United States Supreme Court that says that parental rights are protected under the First Amendment at strict scrutiny, over and over and over again. You're going to see that everywhere. No attorney worth their salt would ever tell you that that's not the case. And a good attorney would not say, oh, yeah, that's true, but not in family court. No, it is true in family court. Just because you're in family court and your ex doesn't like you anymore doesn't mean that the Constitution no longer protects your parental rights. So if you're inviting the judge's opinion on stepmom, the school, my son's older now, what do you think? You're kind of inviting the judge's discretion. What I would do is I would go back and I would use the laws. You can use the American with Disabilities Act. That's a very strong law. That's a suggestion. That's what I suggest to everybody. If your child qualifies for protection under the ADA. And also, I would simply use your parental rights. So I would educate yourself on what your parental rights are. My course talks about this quite a bit. And I would lean towards using the law and lead with your rights and invite as little discretion as humanly possible. Because the more discretion we bring in, the more the judge gets to simply keep your child away from you based on their own personal opinion. And bringing in a GAL is assigning away your authority as a parent to a third party, because now the GAL gets to call the shots. The GAL gets to decide what's best for your child. The GAL is basically acting as a substitute teacher for your parental rights. And we don't want to do that. You do not want to bring in a what's that word I'm looking for? You don't want to bring in a decoy. You don't want to bring in a body double. That's the word I'm looking for. You don't want to bring in a body double to stand in and make parental decisions on your behalf when you are more than capable of doing that. Like, we are freaking capable of managing our children. And that doesn't change just because our ex doesn't like us anymore. Because that's really the only difference. Like, the only thing that sets you apart from every other parent on your street that are married is that your ex doesn't like you and that you're in the family court. That's the only thing that's different. You're no different than anybody else. So other people don't need GALs. So why do you? Since when do people in divorce need a GAL? If anything, and I've said this before, the time where we probably could use a GAL, and I'm mostly joking, but not really, is when we're in a massive crisis. Hurricane Katrina hits our city, and our house is underwater, and we have no food, we have no shelter. Okay, maybe a GAL might be nice because we could probably use some help with our kids, because we literally can't take care of our kids because a freaking hurricane came, or a fire, or an illness. Both parents have terminal cancer. Like, usually with major catastrophes, that's when it might be a good idea to bring in a guardian ad litem, when both parents are like incapacitated. But even then, I'm not so sure about that. So I'm going to move on to the next question. So I hope that helps. Okay, so this is a really, 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 really juicy question. And I love this question. And I can't wait to do a whole podcast on this question. It's so incredible. So I was asked to keep this more confidential, so I'm going to summarize. So this parent's insurance is paying for forced therapy. In other words, the judge told me I need therapy. I'm billing, my insurance is paying for my therapy. It's like $200 a session. And the therapy is therapy that I don't qualify for, because the judge gave me a fake diagnosis from the bench. Judges like to play doctor. They like to make up mental illnesses from the bench, and they'd like to order you into therapy based on a mental illness that they made up without a proper evaluation. So it's a botched therapy. It's a botched diagnosis. And you have a therapist now treating you for a condition that you don't have, and your insurance is paying for it. Okay, so I have insurance with, say, Cigna, and I pay $40 a session for my therapy, or whatever, $20, and then Cigna pays the other $150 or something. So the people, and this is why family court is a problem for everybody. Everybody should care about family court reform, because this is costly to everybody. I'm telling you, when I was running for office a couple years back, I always said family court corruption hurts everybody. It hurts taxpayers, because taxpayers are funding the problems that these kids are developing when they go into special ed, and they need, and they need extra care in their elementary schools and their junior high schools to make up for the fact that they no longer have one of their parents around. And so, that's just one example. I mean, taxpayers are paying for foreclosures. I mean, this is a problem for everybody. So one of the big problems is that insurance companies are paying for fake treatment. They're paying for parents to sit through fake therapy. and be treated for a condition that they don't suffer from. And so without revealing this person's identity, what I would do, I would love to see a parent jump all over this. My husband and I talk about this all the time with regard to insurance fraud, because he works for an insurance company. But when parents are billing insurance companies for fake family court induced treatments or whatever, diagnosed treatment, that's insurance fraud. And so, personally, I would open up a fraud investigation with my insurance company. I would not report yourself, but I would just say, look, I'm being court ordered into fake therapy for a condition I don't have, and you're paying for this. Do you want to open up an investigation? I want to see a parent pioneer that. I would love to see that. If I was ordered into fake therapy, I would have done that. So I would love to see a parent do that. And the parent who wrote the question in, I think that you should do that. Open up an investigation. And if your insurance company is a bunch of wussies and don't want to look into it because they're afraid of judges, because everybody's afraid of judges because people are stupid, then they might not do anything. But at least you're putting your line in the sand, and you're making a position on the issue, and you're kind of getting into this activist mindset by pushing this. And I think this is a great thing to bring to your legislator. I would love to see insurance companies create a whole division just questioning family court orders that force therapy, and forcing therapy on your kids too. Judges love to force our kids into freaking treatment on conditions that they create themselves. The judge will take a parent away from a kid and then put that kid into therapy. I think that's fraud. That is freaking fraud. It's a misuse of the resources. So let's get to the next question. This one came through email, so let me pull that up. Okay. I really like this question because I have personal experience with this one. How do you get past the idea that you don't deserve happiness or success? I have mishandled my own court case because I've been weak, fearful, exhausted, and exasperated, and my ex has all the power and control and the money. I can totally relate to the poverty mindset that I hear you talk about. Yes, welcome to my whole life, basically. And so my issues that you're describing, I suffered from that, up until very recently. And I have learned that those challenges I have came before I was even in court. And they manifested themselves worse with my custody case. So I think that if we have this mindset, it's very, very possible that we had this prior to our court cases even being opened. And what I did, I started listening to podcasts, and I started reading some really good books. I'd say podcasts, books, and meditations have in equal parts. I think it was literally 30% podcast, 30% meditation. A really good person. Oh my God, my mind is blank. I'll send you my personal recipe of what I use, and I'll actually share that with the group. It's just what worked for me. And I'll share that with you, but that's what I had to do. I had to rely on external input. And I did a lot of it. It was years. It was at least 3 years of constant exposure to other ways of thinking. And that's what worked for me. I'm not the kind of person that could just wake up and be like, I deserve happiness and just do that. I had to do a lot of affirmations as well. I'd say that's 10% of my portfolio was affirmations. So affirmations, meditations, books, and podcasts. A little bit of therapy as well, but not a lot. Coaching, yes. How much coaching did I get? I want to say I spent maybe only $1,000 on coaching. But you could totally change your mindset with $1,000 easily. Between books, courses are also useful. My course gets into this in module 1. So we kind of get into this early on in the training. So, and I do actually include a lot of resources in my course too. So that's what I did personally. And I really think that that's effective for most people. If anyone else has other suggestions, put that in the comments. What worked for you to break out of your impoverishment, your spiritual impoverishment, and your feeling that you don't deserve happiness or success because of all the treatment that you've suffered through. And when you have a judge writing pages and pages and pages of bad stuff about you. So interestingly, I had 3 different judges write a lot of bad stuff about me. And I have about 100 pages of nasty things written about me collectively over the past 10 years by 3 different judges. And so when we read negative opinions about us written by judges, for some reason, it seems to have more of a punch than if like your next door neighbor wrote it. So we have to also stop thinking that these judges are so special, because they're not. They are not special. Judges are narcissists who chose family law as their profession, because if you're a narcissist, I think family law is a great place to work. It's like you get to kind of like exploit you get to showcase your narcissism, and you get to make money off of being a narcissist. And then so judges are former attorneys, right? And so you're a dickhead attorney for 30 years, and then you get promoted to judge, and then you're just an asshole judge. So you're not that special. You passed the freaking bar exam, you passed the LSATs, you probably made a lot of money, you probably destroyed a lot of families, and that's your success. That's your freaking resume. Congratulations. You're not special. So these people aren't special. They're being paid to be professional assholes. So don't think if a judge wrote it, it must mean more than if someone else wrote it. So let's see here. Okay, let me get to the next question. And that is also an email. I think. No, it's not. Yes, it is. Sorry. Here we go. Yep. Oh, okay. So the question is, can you explain what de facto means? So this is a legal term. You can Google this. It's very accessible. I like the term a lot, and I like to use it. De facto basically means as though it is. Let me get the actual legal term. There's an actual term for it. De facto. I'm just Googling it. De facto. In law and government, de facto describes practices that exist in reality, even though they are not officially recognized by laws. It is commonly used to refer to what happens in practice, in contrast with some legal term they throw in there that I can't pronounce, which refers to things that happen according to law. Okay, that is useless, right? Don't you love researching legal terms and you're like, yeah, I don't even know what that means. All right, so if something is a de facto, a really good example is when you go to family court and you go through a trial and you are left with supervised visits. And that's it. No visibility into your child's medical records. You can't contact the school. You can't drive your kid to school. You can't pick your kid up from school. You're down to 1 hour a week with your child in a dirty room with a lady with short hair and a clipboard taking notes about how you're interacting with your child. That is your parenting now. Your parenting is reduced to that. And there's a lot of people in this group that are in that situation. So in my opinion, that is a de facto termination of parental rights, because in my opinion, not legal advice, but my opinion is that when you have your parental rights terminated on a best interest of the child standard, you went through a de facto termination. The judge issued a de facto termination of parental rights, which means you lost your parental rights, but you didn't have the actual legal process You didn't have the legal mechanisms didn't happen. You didn't get a petition from the CPS in your state. They didn't file a petition. They didn't serve you with charges. They didn't offer you a case plan. They didn't notify you of your rights. So there, if you want to terminate a parent's rights, CPS has to do a lot of work. They have to jump through a lot of hoops. But in family court, you can just lose your parental rights on a best interest standard. So I call that a de facto termination of parental rights, because you went through a termination without the process. And someone says de facto equals by default commonly known. Oh my gosh, it's such a beautiful term. That's a beautiful way to put it. So by default. So also I mentioned earlier that sometimes judges will make diagnoses from the bench. So the judge issued a de facto diagnosis of you. I don't know if I use that term correctly, but it really does mean by default commonly known. My attorney, when I was first going to court way in the beginning, my attorney told the judge that me and my ex had a de facto marriage because we were living as a married couple, but not really married. So it's common law, so I hope that helps explain it. But what I have said in many times in my court case was I said, Your Honor, I went through a de facto termination of my parental rights because I don't have any say in medical decision-making or educational decision-making. And so this is going to sort of lead to my next question as well, because can you lose your parental rights and not really lose them? Yes, a parent asked about that. So I'll get to that question in a second. What I did say in my court case was I said, if you do all this on a best interest standard, that's a de facto termination of my parental rights because nobody took me through the formal proceedings. Nobody did the things that CPS has to do. So why is it that you go to one court and you go through all these formal proceedings and then you go into another court and you have just a hodgepodge best interest of the child and you're left with like the same result? Because kids who are in CPS care also have their access to their parent on a supervised visitation status. Or they're in supervised visits with their parents when your kids are in foster care. So why don't I get the same treatment when I'm on supervised visits in a divorce, after a divorce? It doesn't make any sense. So if you're ever put on supervised visits, ask to be treated as though a parent were in CPS. If you want to put a parent in CPS on supervised visits, you got to do a lot of things. CPS has to do a lot of things. They have to serve you with formal charges. They have to offer you a chance to have counsel. They have to do a lot of things, and they have to achieve probable cause. They have to show cause and not use a best interest of the child standard. Okay, so the next question is kind of similar. If I lost my rights, how is it that I'm allowed to see my son? Let me read the whole question, though, okay? Let's see here. If I lost my rights, how is it that I can see my son? So rights are broken up into different pieces. There's physical, there's your right to have physical contact with your child. Like I hate the word visitation with a passion, but it's effectively visitation rights. So you have visitation rights, and then you have like medical decision-making rights, and then you have religious decision-making rights, and then the other piece is educational rights. So our parental rights are split up. So I have a former student who has no medical decision-making, but she has all of the educational decision-making. I kind of think that's kind of crappy because I think both parents should have equal say in both things, providing that they're fit parents. But so sometimes a judge will terminate your rights in one area and then give you sole custody in another area. Again, I think that's just crazy. I kind of understand why they do it, but I still think it's not equitable or fair. And I think it's fundamentally flawed. But I guess people do that. I don't know. Freaking family court's ridiculous. Because you can go halvesies on a lot of things with education, with medical, with dental, religion. You could absolutely protect both parents' rights with religion. Who cares if the kid has two religions? Okay. I mean, I know that's probably against a lot of religions to have another religion, but let the child figure that out. Let that not be a state issue. Medical, I think, unless it's a surgery or not having surgery, like most parents can preserve their medical rights very broadly, even after divorce, unless it's yes or no. In that case, a judge does need to serve as a tiebreaker. But to terminate your rights in one area and give you sole custody in another area, I just think is fundamentally unfair. That's just my opinion. But the full question here is, I lost custody of both my children in 2018. Fast forward to present, I still only see one child every Wednesday and 4 nights a month. Oh, you have my schedule. Congratulations. Doesn't it feel great? 4 nights a month. He goes to school where he lives, which is not in the school district I live in. Yeah, same here. If I lost my rights, why am I being held responsible for failing grades and missing assignments? I love that question. I'll get to that. I know the opposing counsel and the judge have been good friends for a long time. If I lost my rights, how am I allowed to see him? So the answer to that question is you lost your legal rights, but didn't lose your visitation rights. I'm sorry, I hate that word. Worst word in the world. You lost your you still have visitation rights, but you lost your legal rights. And so my therapist agrees that if I lost my rights, I wouldn't be allowed to see him and I would not be on the birth certificate. So I I personally don't think anyone could ever be taken off a birth certificate ever. So you could be 85 years old, and if you were adopted out when you were 2 hours old, your biological mom would still be on that birth certificate, in my opinion. I think. I mean, I poke around on Ancestry.com a lot, and that's just what I've seen over and over again. Like, whoever you're born from is on the birth certificate. A judge would never erase a parent off a birth certificate. Not yet. I know we're headed towards that kind of dystopian culture, but we're not going to let that happen, right, guys? Because we're going to put some reform in before that happens. But I wouldn't be surprised if a judge did that, but I don't think you could ever be taken off a birth certificate. So being responsible for failing grades. Okay, so here's a question. So parents do this all the time. They say, I'm being blamed for my child not having friends. I'm being blamed for my child failing school, or I'm being blamed for my child being depressed. I'm being blamed for my child overeating or not eating enough. So here's a question. Who's blaming you? Is it your ex, their attorney? So a lot of times when parents come to me with that, I'll be like, well, who's blaming you? They say, oh, my ex. I'm like, well, who fucking cares? Who cares if your ex is saying that? Just say, okay, thanks, bye. Thanks for sharing your opinion. That's what I would say. If my ex called me up, if my ex texts me and says, you're the reason, I'd be like, oh, okay, well, thank you so much for sharing your thoughts. Have a great day. And I would put my phone away and I wouldn't even check it again. If the ex's attorney is saying that about you, same thing. Oh, thank you, Mr. Attorney so-and-so. Thank you for sharing your thoughts. Have a great day. Boop, boop. You put your phone away. Leave it alone. Who cares? Who cares what these people think? If an evaluator is saying it, first of all, why did you bring in an evaluator in the first place? But if it's too late, you already consented to the evaluation, and the evaluator wants to pop off about how you're responsible for the grades. You can just say, okay, great. Whatever you want to put in your report, that's fine. I'm going to ask you to prove it. I'm going to put your ass on the witness stand and make you prove it. No, don't say that. Don't give away your strategy. But no, if you're being blamed by an evaluator or a GAL for your child not having friends or not eating enough or not eating well or having an attitude problem, or if you're being blamed for that, this is not legal advice. This is what I would do. I would put that person on the stand and be like, okay, where's your proof? And they won't be able to show it, because these people make terrible witnesses. They make really bad witnesses. They're doing that to make you feel like crap about yourself so that you lose it and don't fight. And you got to freaking keep it together and fight anyway. Like, just put these people on the stand and make them prove it. Okay. It is literally impossible to ever prove that little Johnny's failing algebra because of you. You can't do that. No one could do that. No one could ever prove that it's a parent's fault, unless, especially if you're barely with your child. You're with your child 4 days a month. Unless they could prove that every single Monday after you're with them, they weren't handing in their assignments, maybe. But even then, is that reason to take your child away? Why not just let the child get an F and make it the child's fault? That's the kind of parent I am. I'm like, hey, if my son doesn't want to hand something in, he gets an F. That's his problem, not mine. Not my problem. Sorry, I'm just getting angry. So what I would do, I would make them prove it. And if your evaluator has your child's report card with all the teacher comments and everything, then say that you need to cross-examine all the teachers. No, I'm kidding. No, I would personally, not legal advice, I would say, this is a hearsay document. The report card is hearsay because the teachers who wrote these notes aren't here to testify to the validity of the statements. And I would challenge the legal basis on, can this interfere with my ability to parent my child equally? Do kids who are failing history get put into foster care because they're failing history and their parents aren't helping them not fail history? And if you can't take away a child from a married home because they're failing a grade, then they should not be taken away from a divorced parent for the same exact thing. I think grades in family court, I don't think they belong there. That's between the child, the parent, and the school. It's not a freaking government concern. The government doesn't need to get involved because your child's failing at one class. If your child's failing, they can stay back. They can suffer their own consequences. That's just part of life. I flunked out of school a million times. I had to repeat. My parents were certainly not being questioned by the authorities over it. So anyway, I think that is just the dumbest thing. I hope I answered your question. Yeah, so you do have rights. You just probably had a termination of your legal rights, and in which case I would go back to court and ask for my rights back. I'd say, hey, I want my rights back. I'm a fit parent. I want my rights back. You might have to show a change in circumstances to get your foot back into court, but that's what I would do, because you're probably sick of this, right? Like, it's been at least since 2018. So you've already been suffering for 3 years in the minimum. Okay. All right. What do I do about perjury after the fact? Okay, it's been 6 months. I'm looking through my files and I'm finding out that the evaluator lied. Okay. You can do a motion to reopen. This is not legal advice. This is just what I would do. You could do a motion to reopen based on fraud. I don't know if that's, I think that's available in your state, because I believe that's in the Federal Rules of Civil Procedure, the manual. So do get that manual. You could download it or you could access it online. Federal Rules of Civil Procedure, and just type into the search bar, motion to reopen based on fraud. I believe you can open a case on fraud in any state, because it's fraud. Like, if something was, if a judgment was obtained by fraud, then it's a void judgment, technically, according to the law. This isn't legal advice. I'm just saying what's written down already by other people. And you can open the case. The problem I see with this kind of stuff is a judge could easily say, well, I would have made that decision anyway, regardless of that evaluator's testimony. And that's just their easy way out. That's their escape hatch. That's their way of getting away with what they did and not having to look at their mistakes. One thing that you could do is, and depending on how long it's been. So if it's been 6 months, that's still kind of early. It's too late to appeal. You can do a motion to reopen. If it's been 2 years, and you're learning this, because I did that. I remember, like, 3 years after my son was taken, I found fraud. I was like, oh my God, there's fraud here. And what I did was I filed a motion to modify, in that, I filed a motion to modify because it just seemed to make more sense. But this is huge. Because there was fraud in my case, I brought that. So another thing is, you can bring up fraud at any time. You can bring up, you don't have to file a motion. I don't think, I could be wrong. Look it up. don't take my word for it. But I believe at any time you can raise an issue of fraud, even if it happened 20 years ago. There's no statute of limitations on fraud. So what I did in my case in 2013, which was my second trial, I brought up the fraudulent report from 2010. I hope you guys are following me. Because, okay, 2010, I had a fraudulent report written. I found out in 2013 that there was fraud. Okay, I learned that. I went back to court on a motion to modify. The judge wanted to dig up the report from 2010 to make an opinion. Okay, they like to do that. They like to recycle the old garbage from the past and create new opinions based on old garbage. So the judge started digging through the old report, and I was able to get that report thrown out of evidence because I alleged fraud. And I put the evaluator on the stand, and I got the evaluator to admit that she lied, which was huge. It was amazing. Very vindicating, getting someone to admit that they lied. I did get the report thrown out, but the end result was that I got my parenting time cut in half. So you can get a report thrown out possibly based on fraud if you're successful. For me, it wasn't that difficult. It was very easy. It was very apparent. And a lot of you guys are finding fraud in your case, and it's very obvious. It's not something you have to dig very deep for. It's very, very, very obvious. So even if you could raise the fraud issue and have that piece of evidence thrown out, oftentimes the judge might just keep that decision anyway. So I think you need more than just getting something thrown out based on fraud. But bringing that up can at least get you to get the case open again. So I would talk to an attorney. This is when it's worth spending 2 hours with an attorney. Spend the money, spend $500 and sit down and say, I want to get this thing thrown out. This is why I lost my child. It's fraud. Here's the fraud. I want to bring this up. See what your attorney would say. Don't get a lazy, stupid family court attorney that's going to say, well, it's all about the best interest. The judge is just, no. Go to the heart of the issue, which was my son or daughter was taken from me based on fraud. Forget about best interest. I no longer have a quality relationship with my child because of somebody's literally lying under oath and putting a fake thing in the record. And focus on that and try to and get an attorney that is going to care about that and not tell you, be like, oh, let's just file another motion to modify and let's see what the judge says. Don't do that. Don't. I would not let an attorney allow judges to have all that discretion when you have clear evidence of fraud. And most of you do. Like almost every freaking person that's ever contacted me has fraud in their case. So that's what I would do. I hope that isn't such an, too long of an answer. I get really, really angry about this kind of stuff. Okay. Let's see here. I want to file a motion. Oh, this is a good one. I want to file a motion, but my son is so alienated that I think it will not be helpful. Okay. So I think what you're alluding to is that your son will somehow have a say in this. Like, I want to file a motion, but my son is very alienated. I don't think it would be helpful. I'm assuming you want to file a motion to somehow get your parental rights back. So what I would do, this is just my opinion, not legal advice. I have to keep saying that over and over again. I would go back to court and focus solely on the fact that you have a right to parent your child as you see fit without government interference. And if the judge says, well, we need to talk to the child, we need to talk to the child's therapist, I would very heavily object to that. If you have a child who's being brainwashed and alienated, the last thing, in my opinion, this is just my opinion, a lot of parents will go the other way and try to bring in a professional to say that the child is alienated. I am not a fan of that. The alienation is such a horrible thing that they throw around in court. They use alienation to take kids away from protective parents, and then they ignore true alienation on purpose. This is all done on purpose. What I would do is, if you believe your child is truly alienated and brainwashed, I would fight and say, I have the right to parent my child, period. And if the judge says, well, we want to talk to the child's therapist, we want to talk to the child, I would say, hell to the no. Absolutely not. My child does not get to make adult decisions on whether or not they get to see a parent. And point out, kids in married couples' homes don't get to emancipate themselves from a parent unless they're 16. I mean, I would say if your child is under 16, I would absolutely use that. A 12-year-old cannot legally emancipate themselves from a parent when the parents are married. So why are we letting 12-year-olds do that when the parents are divorced? I would point that out and say, this is discrimination based on marital status. Why is my marital status the thing that's not, like, why must I be married to the other parent to have protection from this? Because if my 12-year-old hates me, I have a daughter, I have two daughters, okay, and I'm legally married. If my two daughters choose to not like me when they're teenagers, I'm still protected, y'all. I don't have to worry about a thing, okay? I don't have to worry about anything. I don't have to worry about the government taking my kids away if they choose not to like me when they're teenagers, which of course they won't. They're not going to like me when they're teenagers. So why would I be protected by virtue of being married when I would not be protected if I wasn't married? So I would point that out. That's discrimination based on marital status. I would totally say that, 100%. And if the judge insists on getting your child to speak, I would fight that like crazy. But if the judge tries to use your child's opinions, a lot of people are going to disagree with me on this. But again, this is not legal advice. This is just what I would do. I would say, great, I want to cross-examine my child. I want to put my child on the witness stand. You're speaking for my child. The GAL is speaking for my child. If you get a GAL, which I don't think you should, if the therapist is dragged in to speak for your child, great. I want to interview my own child. I want to put my own child on the stand and cross-examine. The judge will freak out. They're going to throw an absolute hissy fit because judges act like they care about kids being witnesses because they're so protective of these children. Oh, we can't let your child be a witness. We're just going to take your child away from you. That's not going to harm your child, but being a witness is going to harm your child. So a judge doesn't get to decide what is harmful for your child and not harmful. That's not their job. That's your job. You get to choose what's good for your child and what's not. And honestly, this is where I'm at in my life. Is it harmful for me to cross-examine my child in family court? Yes, of course. It's going to be traumatizing for him, but it's going to be more traumatizing to have him taken away from me because of somebody else's opinion of what my child wants. So I would rather harm my child by cross-examining him to prevent more harm by having him lose me altogether as a parent. And I would say that. I would totally say all that. Just my opinion, not legal advice. So no, I don't think your child should be involved in the proceeding at all. Kids don't get to cut themselves off from their parents. Okay, so I have time for one more question because we're at an hour now. Oh, this is a hard question. Why did I choose this one? No, it's okay. This is from one of my students. Well, sort of. No, former student. Sorry. Yeah, former student. Okay. Okay, the question is, and I'm going to keep her identity quiet. Should I go to therapy? Okay, I'm trying to figure out how to keep her anonymous because she wants me to be anonymous. Okay. Should you report to your therapist that you're suffering? Okay. Okay, you're hurting, you're traumatized, you're going through a custody battle, you're scared, you're freaking out, and it's impacting your ability to parent, right? Of course, who doesn't have issues parenting when they're going through this? You're going to not be as present for your kids. That's just a fact of life, and that's true for anything. That's true if you have a parent that's dying of an illness, if you just lost a job, if you're sick, you have an illness, you have money problems, you know, roof blows off your house, your dog dies, your cat dies, your neighbor's an ass, you know, whatever things that happen in life is going to impact your ability to parent, because that's just life. That's life. It's going to impact your ability to be a good boyfriend or girlfriend. It's going to impact your ability to be a good employee, because that's called life. So if you're talking to a therapist and you're concerned with that, and you want to be a better parent to your children, how do you express that without getting CPS called on you? Because in this case, this therapist, you can't make this up. This therapist was appointed by the court. So I think you all know the answer to this. I hate that this is true, because you probably have a decent relationship with this person, but I'm not okay. And I really can't, I'm not qualified to really give a good answer, because I don't want to be like, don't share that, and then you not get the help you need, and then your child suffers, and then you get in trouble. You know, I don't want to do that. So I'm not qualified to give a good answer, but I'm just going to tell you what I would do. If I were in your position, I would not talk about that, about my parenting. I mean, if you have to freaking say stupid things like, "Oh, I parent great, everything's perfect," fine. I mean, say whatever you want to say, you know. But you can get help with that issue by reading books, listening to podcasts, without interacting with another person. You can just get that help through other channels like meditations, books. I mean, there has to be a book on how to be a better parent, and get recommendations. Like, ask other people, hey, can anyone recommend a good book on how to be a better parent in a time of crisis? Read memoirs. I mean, God, there's like so much stuff out there. Like, I'm reading a book right now about a mom who had to suffer through World War II with a 10-year-old daughter. So even like reading memoirs and like true stories of other parents who've had to go through major issues and parent, you could get inspiration from that. That's personally, like, stuff like that helps me be a better parent. Reading true stories of other people who've gone through hell and back with kids. Everybody's done it. Every single person who's ever raised a child has had to raise that child through a crisis. I don't know anybody. My great grandmother, her sister was killed by a milk truck when she was 6 years old. My great grandmother was 12, and my great grandmother had to do a lot of the parenting, like the child rearing, because her parents were grieving so badly. Because my great grandfather had his back turned, and her 6-year-old sister got hit by a milk truck. And the father plummeted from there, and the mother plummeted. So my great grandmother had to raise the little siblings. And we've been suffering for all of humanity. It's part of life, is suffering. And part of raising children is suffering at some point or another while you're raising those children. And every family I know has had to raise children through major crises. I don't know why my great grandmother, why that popped up. She must have done a spiritual presence during this live stream. So I would try to get your help from other places. And we actually have 1 minute left to answer questions that are in the comments. So this is a huge question. What about COVID vaccines when both parents don't agree? Okay, so both parents don't agree. Both parents don't agree to get it? I'm assuming that you mean one parent wants it and the other parent doesn't. Holy crap. Okay. Oh my God. Horrible, 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 horrible situation. I actually have a 75-minute video on this. And so you're coming up as anonymous in my live stream. So send me a private message and let me know who you are. I think once it's published to Facebook, your identity will show up. But I'm going to send you a video that I made 2 years ago on this issue. That's a horrible freaking situation to be in. I'm going to New Mexico Appellate Court. I have appellate super lawyers. I'd like to get information from you so I can relate information to them and what works and they can consider. Yeah, absolutely. That's great. I'm so glad that you're pursuing that. As long as you're in that statute of limitations, if you have time to file your appeal, if you want an extension, see if you can file for an extension, give yourself extra time. Every state's different with how much time they allow for you to wait before you appeal. Railroaded is a great term. Oh, what if a judge appointed a GAL and had no choice? So here's an interesting thing, and I freaking hate this. I see this all the time. And this was true in my own case, of course. So if the judge appointed a GAL and you had no choice, let me ask you something. Did a GAL ever present one of these to you, a piece of paper where you had to sign the bottom? So oftentimes a judge will appoint a GAL. That's actually not true. I mean, I would almost say the appointment isn't legitimized until you sign that contract. But I don't think that's necessarily true because a judge could issue a court order. But if you don't sign that contract, then you're kind of illegitimizing what the judge did. So it's kind of interesting because the judge can make an order, but if you don't sign that contract, like then what is there still an order? Like, is it a legal thing or not? And if the judge is issuing an order, then why do you have to sign a contract? So we have that in Connecticut where parents are ordered into something and then they have to sign a contract. So it's like, well, why are you having to sign something if it's an order? So I would not sign anything. This is just my personal experience. It's not legal advice. I would talk to a contract attorney, or I would talk to an attorney. Yeah, we should absolutely talk because I have a live stream on this issue. If you're on Facebook, I could tag you in it. I think I did a live stream on this topic. But yeah, if a judge appointed a GAL and you had no choice, then I would appeal because that's a forced contract and you can't be forced into a contract. I talk a ton about this. I think I have like 2 podcast episodes on this. So we should email and I'll try to get you that resource. Is it your opinion that we can refuse a GAL or psychological report if we've already had one and both went really well? Yeah, I mean, again, Patient's Bill of Rights, informed consent laws. We have the right to opt out of treatment. We have the right to not participate in any treatment that we don't want to. And again, the GAL, you could refuse a GAL because we have the right to enter into contracts as we see fit. No one can force you into a contract. It's compelled speech. We talked about that all the time. Oh gosh, it's like being forced to have surgery you don't need. Isn't that just, it is. It's surgery on your brain when you're thrown into court or into therapy. It's so ridiculous. Interesting de facto termination of my parental rights. CPS had more rights to their child. Yes. Holy crap. Someone says, have fun. Don't sign shit. I never know who's saying this because in this platform, everybody comes up as anonymous. And it's just so funny when people say things. I don't know who you are. All right. So again, if you guys want to participate in the live stream, the podcast review, do leave send me the review, either email me, monica@momsunshackled.com. Tell me your review. Make sure you listen to an actual podcast episode first. Don't just be like, oh, it's all good. I like this podcast. That won't qualify. You have to actually review it. And I'll enter you into the drawing. And if you want to private message me your personal review on the podcast, then I will enter you as well. I'll link my podcast into this live stream. And I'm sorry for the issues with leaving a review. Looks like we don't have any more questions. All right. The last comment here is don't sign shit. I have to agree with you. All right. Excellent. I so appreciate you guys coming on. So again, the drawing for the contest will be next week, June 1st, which is the anniversary of the best interest of the parent. All right. Thanks for coming on. We'll have a great, I can't talk. Have a great night. Okay. Bye-bye.